All right, Mr. Pelt, we're just waiting for your client to come in,
Thank you.
and then we'll take this matter up. Is there anyone on the hallway?
There's the, I think let's see.
Walter Prince?
Yes.
There he is.
Okay. All right, we're going to go on the record. If you'll come up, Mr. Prince, and state if you'll stand in. All right, thank you. Court is calling 2025 CR 006467 State versus Walter Prince. Could I have parties announced for the state? Defense?
Joseph Appel for the defense.
And are you Mr. Prince? All right, your attorney is appearing by Zoom. Do you have any objections to his appearing by Zoom? All right. Counsel, have you received all discovery? Did you review it with your client?
I believe I've received all discovery, Your Honor, and I have an opportunity to review with Mr. Prince, and we have discussed it several times.
All right, the court will find that the state is in compliance with discovery. Mr. Prince, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you weigh the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
To an extent, we're proceeding on count one and we're waiving count two, and then we are proceeding on the enhancement allegations as well.
Any objection?
No, Your Honor.
Mr. Prince, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with theft of property, $2,500 to $30,000. Normally, that's a state jail felony. The range of punishment would be anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If the state is able to prove beyond a reasonable doubt the enhancements, then your range of punishment will be anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you're giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Prince, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and not allowed re-entry into the United States. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count one. They're waiving count two. You are to agree that you've been previously convicted of one or two or more felonies for purposes of enhancement. Punishments be assessed at a cap of 7 years in the prison. There's a $1,500 fine. The state opposes your application. There's to be restitution to the complainant, if any, and no contact with UTHSC except for medical treatment. Did you understand that to be the plea?
Yes.
Defense?
That is my understanding, Your Honor.
State?
That is, Your Honor, and just for clarification, it was UT Health Science Center is what UTHSC stands for.
Yes. Did you review the document? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, did you understand you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
There have not been any such motions.
Then to the offenses charged in count one, how do you plead? Guilty, not guilty, or no contest? To the enhancements, how do you plead? True or not true? And that's true to both enhancements? State any evidence to support the plea?
Yes, ma'am. State offers in the evidence states exhibit one with its attachments.
No objections from the defense, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports and judgments, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments, and the court will review the same. Right, after reviewing states exhibits one and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudications. The court will find the enhancements true based upon your plea of true and based upon states exhibits one and attachments. Counsel, are you requesting a PSI?
We are, Your Honor.
All right, I need a PSI date, please. And TAP evaluation. All right, December 16th. Is there a need for a MIC evaluation, counsel?
I don't believe so, Your Honor.
All right, thank you. Just meet with probation and they'll tell you what you need to do. And once you sign the reset form, you're excused. You're welcome.
Thank you, Judge. May I be excused?
Yes. All right, Mr. Simpkins, who do you have?
Mandy Wallace, Your Honor.
Mandy Wallace. All right, they're going to swear her in, then we'll take up that.
Thank you, Judge.
Anyone else ready? Okay. Yeah. Thank you. All right, Mandy Wallace. If you'll come down, please. And probation, this is an application. Court is calling 2025 CR 011527, State versus Mandy Wallace. Could I have parties announced for the record?
Megan Galloway for the state.
Christopher Simpkins for the defense.
And are you Mandy Wallace?
Yes.
Counsel, you received all discovery. Did you review it with your client?
I have, and I signed the certification.
Court will find that the state is in compliance with discovery. Ms. Wallace, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented
Yes, sir.
on all counts?
Yes, sir.
All right, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
You're charged with credit card or debit abuse and 5 counts. Each of those counts is a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, she was.
Ms. Wallace, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Did you understand if you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and not reentry?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $0 fine. State recommends deferred adjudication. There's to be restitution of $245.21 to Frost Bank. Did you understand that to be the plea?
Yes.
State, is that the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Judge.
I'm sorry, defense, is that the plea?
Yes, Judge.
For some reason, we can't hear you.
That's weird.
I don't know what is happening.
Can you hear me? Can you hear me, Judge?
All right, any objection to the court chatting with Mr. Simpkins and
Oh.
repeating his answers in the chat?
No, Your Honor.
Judge, can you hear me?
All right, the court is asking the defense counsel if he understand that to be the plea. He states yes. And defense, are you able to hear us?
I can hear you, Judge.
All right, then defense, if you'll just make sure you put your answers in the chat for me, and then I will read those. And according to the plea bargain agreement, any objection to the court adding that you all are proceeding on counts 1 through 5?
No objection.
Any objection? Defense. All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions? Defense attorney responds no. Outside the agreement, the state is recommending that your community supervision be for a term of 5 years, that there be a TAP evaluation, 200 hours of community service restitution, no contact with the complainant, the anti-theft course, and the life skills course. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your
Then to count 1, how do you plead? Guilty, not guilty, or no contest?
Honor. Test.
How do you plead to count 2?
No contest.
Count 3?
No contest.
Count 4?
No contest.
Count 5?
No contest.
State any evidence.
State offers states 1 and attachment.
Defense, do you have any objections to states 1 and attachments? Defense responds no. Ms. Wallace, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing? Oh, just 1 second. Defense, yes. Defense attorney says yes, so we're proceeding with sentencing. Is there anything you wish to say on behalf of your client, defense? All right, defense states he's asking that I follow the plea bargain agreement. All right, Ms. Wallace, that was mighty bold of you to take somebody else's credit card and you're enjoying a pedicure or manicure at a salon. Why would you do this?
It's a card, the wallet was on the ground, I picked it up and it was just the instinct thing that I had. Just a bad instinct.
And I don't know why these places keep allowing people to use credit card and they don't even ask for identification.
Right.
And the guy, well, I mean, you're saying right, but you shouldn't have been doing it either. And then you have them, and this credit card comes back to a man, and I'm sure there's a man's name on it, and they don't even say anything to you. Did they question you about why you had the credit card?
No, ma'am.
How are you going to pay back this $245 to Frost Bank?
With work, construction job. I have a day labor company that I work for.
Why were you not working before?
Well, I mean, I worked part-time with pay setters.
But I mean, why would you take a credit card and use it? Why not use your own money?
I said it was just a bad instinct that I had at the time.
How old are you?
I'm 46.
And you didn't have any fear in your heart each time you were going to use the credit card at different places?
I did. I was having a bad day. I think I just had a bad day.
Do you have children?
Yes, I do.
And what are their ages?
One just turned 13, 12, and 20.
Do any of them live with you?
They're with their dad.
Have they lived with you ever?
Yes. When they're 5 years old.
All right, so 5 years old is the last time they lived with you.
Yeah.
Why is that?
Because I had a CPS case and the COVID came around and I lost my housing.
Mhm.
And then someone stole my vehicle and I've just been through a lot since then.
So
I
why
haven't
did
got back on my feet.
Child Protective Services get involved in your life?
My ex called Child Protective Services because
Why?
I kicked him out.
No, there has to be something else going on. Was there a
There
drug
drugs
issue?
involved.
I'm sorry, what?
There was drugs involved.
All right, what type of drugs?
Methamphetamines.
Okay, when's the last time you used before you were arrested?
I'm sorry.
When was the last time you used? And I mean, before you were arrested.
Before I was arrested, it was about a week.
Okay, and how often?
I mean, I was using weekly.
Okay. All right. This is what the court will do. The court will sentence you to 5 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release. There should be no employment as a home health care provider or with minors. No unsupervised contact with minors. No residing in homes with minors. There's to be no contact with the complainant. There's to be restitution of $245.21 to Frost Bank. There's to be 200 hours of community service restitution. How far did you go in school?
I went to college, got my GED,
Okay.
and gone to nursing school.
All right. There's going to be 200 hours of community service restitution. I'm going to require parenting classes. Once that's complete, community service hours will be deemed satisfied. Field visits 1 time per month until further notice. In custody, I'm going to want a referral to felony drug court and a TAP evaluation. If not accepted in felony drug court, then follow all TAP recommendations. Probation, there's also a life skills course. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes,
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
yes, Your Honor.
All right, we can go off the record. Here's the thing, you're gonna have to maintain your sobriety. And when you're on probation, you're not allowed to use marijuana unless you have a prescription for it. So don't go testing positive. The felony drug court program is a very good program. So do your best, be honest with them so you can get in that program, okay? And they'll help you get your life together, okay? All right, good luck to you. Thank you, counsel. Right, who's next? All right, yes.
You have those one, right? The one that went there.
Yes.
We already did that, so-
So where's the attorney on DeLeon? Avelina Lopez, are you all ready? Okay, thank you. And Normie, if you can see where Joseph Stateson is. Ready, Ethan? I think that's it. All right, court is calling 2025 CR 009398 State versus Avelina Lopez. Could I have parties announced?
Yeah, we should see it.
Robert Porter, Mr. Lopez.
All right, and are you Mr. Lopez? All right, you entered a plea of no contest on October 7th. You applied for deferred adjudication. The PSI was waived. According to the plea, punishment is to be assessed at a cap of 10 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. The state is opposed to your application. This will run concurrently with 2025 CC 006611, and there's to be restitution, if any, to the complainant. Are both parties ready to proceed with sentencing?
Yes, Your Honor.
All right, any witnesses state?
No, Your Honor.
Defense, any witness? All right, you may call your witness.
We'll call him Terry.
And counsel, if she needs to have a seat, she can have a seat in a chair.
Oh, it's okay.
All right, you may be seated. All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. I'm going to need you to keep your voice up because the court reporter has to hear. If you'll state your name for the record.
Terry Dillion.
All right, defense, you may proceed.
Thank you. Good afternoon, Mr.
Good.
A few questions. Thank you.
My heart's broken.
Mr. I don't know, Mr. Lopez.
This time,
Is your son? How many children do you have?
3.
What does he follow that line?
Mhm.
Should they?
Mhm.
Now, Ms. Lopez, does your son live with you?
If you do it,
Does he live with you?
no,
Where's he at?
he's homeless, sometimes his brother.
Sometimes say. So when you say he's homeless, how long has he been homeless?
Ever since he got divorced,
And you say he got divorced, what caused him to be homeless?
I guess drugs.
Drugs? Okay.
And
Now, when he's homeless, does he still see you?
yes,
And how often does he see you?
almost every day.
What does he do? By see?
He was to make sure if I'm okay, if I need something. That's what I need.
When we go there, what does he do?
Like if I need something from the store, like something.
He would not clean up around.
Yeah, he does my trash.
Now, even though he's homeless, does he work?
Yes, he does.
What does he do?
He does construction, he works in one day. He go in and work that day and then the next day you gotta like that.
Day labor job?
Yeah, we go.
Have you ever seen him be fined?
No,
And how did that feel on you?
no,
And you mentioned something about, you mean by that?
well, he's always like, I use something like
You don't know what kind of.
Mm.
No,
that.
what about alcohol?
Sometimes he comes with beer.
You think that's a big problem as well? Okay, so,
Any
No
questions?
questions.
All right, I just have a few. Any objection? Yes. Okay. So, give me some information about your son. Where did things start going wrong for him as far as the choices he's been making in his life?
Back in the drugs and alcohol,
No, I mean, when did he start on this path that he's on now?
right now. It got worse when he got divorced.
Mhm.
That's when he started being homeless. And he still works. He will work and buy his drugs or something.
And what drugs has he been using?
I know when he was teenage, he used to smoke.
Okay. All right, thank you so much. And thank you for giving me some insight into your son. I appreciate it. All right, anything else?
no further steps, so.
Okay. State you're opposed. You may proceed.
Your Honor, we're asking that you deny his applications and sentence him to 10 years and TDC. And that's based upon the evidence that was stipulated upon, which essentially states that it's alleged that the victim and the defendant got into an argument regarding an alcoholic beverage. they engaged in some sort of physical altercation. And then it died down for a short period of time and the defendant returns with a knife, stabs the victim. That's supported by multiple witness statements that are in stipulations, so we would ask that you deny his application and sentence him to 10 years.
All right, defense.
I agree with the state except for the 10 years and a little bit about, you read the reports. of what
Yes.
transpired. There was, I guess, another homeless gentleman who actually stole a beer. I'm not, condoning his actions. Problem is that at a bus stop where he has had numerous phones stolen from him, I guess that day he had just had enough. And when we say it was a brief time, it was an extremely brief time to the point that we were deciding whether it was going to be self-defense or not. Having said that, Judge, you heard his mother talk about the drugs, but he's not your typical homeless person. I think this is a person that's needs some type of help to get his where he's going, what he's doing. He hasn't fallen off the grid of society. He's still trying to participate in society. And if you look at his criminal history, the type of thing, the state was going to get into that a little bit. Most of it is marijuana based. I think it's K2 and Kush and all that other stuff. No hard drugs, but a lot of smoking and drinking. We're respectfully requesting for adjudication and with any kind of treatment, he is willing to do inpatient treatment, should the court build that route. Life skills to get it back to where it needs to be.
All right, so I have a couple of questions. Number one, and if your client wants to answer it, who is Angelica to him? Was that a friend?
No, I believe, is it the witnesses?
Yes.
I believe all the witnesses were just witnesses in the prosecution. I don't know.
Because, and let me just tell you my issue with granting your application. In the stipulations, it says, Angelica said Avelino accused Tristan of stealing his beer. And they began to fight. Now, other witnesses are saying it was this verbal altercation. And I'm using the word altercation because that's how they put it in the police report. But then they said it became a physical altercation. And Angelica said everyone told them, hey, stop fighting. And she said, then you walked away. And then she said that then you returned and approached Tristan from behind and stabbed him 2 times.
If I may, Judge, it's almost unfair for the court.
No, I'm just saying what's in the steps.
I understand that. What I'm getting at is it's almost unfair. All this was fine.
I'm sorry, what?
All of this was calm.
Okay.
Because it was at a bus stop. And so technically that's right. But when we say walk away, it's just a little verbal things, it was a scuffle.
All right, does
When
anyone,
we said we walk away, it was to walk away.
oh, does
It
anybody,
wasn't like,
It was, that's why I explained it as brief, but it was not like a prolonged,
you didn't-
it was
you
like
didn't
a
walk
minute or
away and
less.
then a minute or two come back. It was a.
so does
it was back.
anybody want to amend the steps for the court to see the video?
I have no objection that the.
Judge, let me just give it burned on a medium for the court to review.
Okay,
It's not in.
Anyway,
okay. Because that would help me, because
Yeah,
just reading the
just-
steps. All right, thank you. If you would like to, you can have a seat. They're going to let me see this and then we'll go from there. All right, Mr. Lopez? All right. See, sometimes that's why it's so important to watch videos because statements read differently than video. So I do see in the video that this appeared to be a continuous altercation. And there really wasn't, I thought maybe from the way the stipulation reads, it reads as though there was a cessation of any type of altercation. And then you come back with the complainant of being unawares, but it appears that this was a continual altercation that started out as a verbal confrontation. Then it turned to a physical altercation. Then it stopped for about 2 seconds. Then it's another physical altercation. And it's all up and down in front of the bus stops. And then you fell into the street, almost got hit by a vehicle, and then the altercation continued. So here's the thing. You only have two choices. These are your two choices. There are no other choices, so do not ask for any other choices. Your first choice is I'll find you guilty. I'll sentence you to 5 years in prison. I'll ask for the therapeutic community. Your other choice is I will give you deferred adjudication. That deferred adjudication will be for 10 years and you are going into inpatient treatment or either felony drug court. Those are your only two options. You have no other option. Which do you choose? Do you want to discuss it with your attorney? All right. All right. All right, the court is going to sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be no residing in households with minors. In custody, we can see if felony drug court will take them. So in custody, there's going to be a referral to felony drug court. If not accepted, there's going to be a TAP evaluation. And I am telling you now, that TAP evaluation, regardless of what it says, you're doing inpatient treatment because you need, it's obvious to the court that you need inpatient treatment. And the reason why I'm going to request a TAP evaluation, even though I'm saying inpatient treatment, is because they will not take you anywhere unless the TAP evaluation has been completed. So Ms. Abrams, TAP evaluation in custody, if not accepted in felony drug court, and he's either going to end up doing SATF or SafeP. If they recommend SafeP, of course, it will be SafeP. If they recommend SATF, it will be SATF. If they don't recommend inpatient at all, it will be SATF. There's going to be field visits 1 time per month for until further notice. There's an affirmative finding of deadly weapon. And do y'all, was there a restitution amount for the complainant or no?
Judge, you made communication with the complainant and he did say that he have the medical bills, but we don't have an exact amount. So I would request just a restitution hearing. That way I can reach out to University Hospital and get documentation of that.
All right, there's to be no contact with Tristan Mills. Ms. Ferguson, I need a restitution hearing in 30 days. All right, we'll have a restitution hearing on November 20th. This will run concurrent with 2025 CC 00611. There's going to be 200 hours of community service restitution. Do you have any children? What are their ages?
17, 21, 24.
Okay. Probation, is there anything else? All right. With regards to the community service hours, 100 hours of those will be waived once you complete anger management. Is there anything else you need from the court to be successful?
No, you're not.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. If you do not get control of your drug use and maintain your sobriety, only one of two things going to happen. Either you're going to end up in prison or in jail, or either somebody's going to have to identify your body, and more likely than not, that will be your mom. So you're going to have to give up this lifestyle. If you do not, there's going to be a problem. And if you can't do it for yourself, then if you love your mom, you need to do it for her, because I'm sure she doesn't want to do this. And I'm sure she is always worried whether or not she's going to get a call that you're dead. You understand? All right, good luck to you. Thank you. Anyone else ready? All right, Norma, did you get an update on Nillum? Okay. All righty. So is anybody ready? Okay,
Page. The fourth.
okay.
Ready.
Right, Steely,
Good afternoon, Judge.
good afternoon. How's it going?
Going well. And the day started out well. That finished early. I was in and out of the words.
Mhm.
8, not in any particular order.
He's catching himself. Okay.
8, 9, 12, again in order.
Mhm.
I go to felony first officer.
Yeah.
144th to 90th. And unfortunately, when I checked out, I didn't see Steve's case after.
Mhm.
But
No, you're usually here. I appreciate that.
I even came in talking to him about another case I had set in 2 days to see if we can get a paperwork started on some of these.
See, and then this one just slips through the cracks. That happens. All right, so this case is new. Where are we on discovery?
I know that one, I believe the case were recently indicted for discovery. I still need time to look through things.
Okay.
And even in one of the case files, they hadn't printed out the tampering with evidence in one case, so I couldn't show the reports. She had questions about that.
Mhm.
However, Joanne Doyle's and myself filed a psychological evaluation. A doctor at the jail filed a letter with one of the reports that the extent of the letter was not detailed, but essentially saying that perhaps they recognized her name, paid the system before, there could be some mental health concerns. So there's psychological evaluation pending with that doctor that we didn't request.
So how are people requesting things for people's clients without conferring with attorneys?
I spoke with her, and she's intelligent, she understands what she's charged with. I don't believe she's gonna be found incompetent. I think she's smart. She's able to communicate with me. If I detected some type of mental health illness or difficulty communicating, I would have requested evaluation on my own. But because I didn't, and it's the doctor, one of the 4 doctors there. There's 4 now, used to be 5, but I don't know.
So was it requested? Do you think it was requested? Because I see she has some misdemeanor cases. Do you think it was a request by the misdemeanor, or are you on the misdemeanors as well? Okay. Because that needs to be addressed, that persons are,
Doctor's letter didn't have details, so we couldn't find it pretty quickly.
okay. I can understand if maybe they had at least reached out to you all and said, we have some concerns, but just to file one without your input.
I do see that the evaluation is scheduled for November 3rd. I'm still getting this other information.
Well, if you don't have any objections, I think the other judges need to be made aware that people who are not the attorney are filing motions or making requests.
Then can you discuss maybe other possibilities?
Oh, no, you'll need to speak to your attorney. Yeah.
The order was presented to that judge, and she granted the competency evaluation. Yeah, I don't. Okay, go to the September 17th, 2025 email. We received this, like, on your date, but September 17th, 2025 University Health letter regarding Adeline Steely. Dr. Brian Scott.
Okay.
It's like, quote, this individual reference of maybe unable to assist her attorney in the preparation of her defense due to mental illness may require a competency evaluation.
All right, so if they're saying may require, then, okay, I stand corrected. They still should not do an awaiting a psych evaluation unless you all requested it.
I know Dr. Scott has been there years.
Yeah, oh, yes.
Excellent.
Oh, he is. I had a lot of clients that he had previously examined. So that's why I'm saying it says may.
And I will tell you, that letter was dated September 17th. We received an email from Magistrate Courts Coordinator, September 17th. And the very next day, September 18th, we received an email that the informal inquiry was scheduled already. So I did appear at the informal inquiry,
Mhm.
which should have been on September 30th, and I literally told Judge Rodriguez what I told you about Dr. Scott. His letter, we didn't
Mhm.
request. But Judge Rodriguez found that was sufficient for the evaluation.
Okay.
And November 2nd or 3rd is not terribly far away.
Mhm.
And I have discussed with my client that I believe that she's likely to be found competent. I'm not a doctor.
Yeah.
I'm a doctor's letter.
Norma, can we recall her for November 10th? All right, we're going to recall you for November 10th. Is that a good date for you?
I'll be.
Okay. All right, we'll bring you back on November 10th. Okay, thank you. Thank you. All right, thank you.
I've already asked the process. Of because that's-
All right, thank you. Uh, 10th. Steely. And you can put that in as discovery. This isn't coming up. All right. And Jason, is Jason DeLeon here?
He is, waiting at satellite judge.
So, let me see. Have I already heard this motion before or no?
No judge, we got an agreement with the state, and we're just wanting to approach on it.
You can take it to Judge Nahara to hear, because I need that person before me. So if you'll let me.
Should I have him stand up here?
No, you, since he's already down in satellite and Judge Nahara's in the
He's waiting in the
basement.
hallway. He's not like in the.
Oh, you may want to take it to Judge Nahara.
Oh, okay.
Yes,
No problem.
just let Ms. Ferguson know.
Yeah.
You're welcome, no problem.
I was like running around, had to go to an ophthalmologist. They said I can't take Ozempic anymore because I'm going blind, like I'll go blind.
What?
Yeah, saying I'm getting like inflammation behind, like around my optic nerve, and it's because of the Ozempic, because of the change in the sugar levels
Mhm.
when it's too drastic.
Mhm.
Something that causes inflammation and damage to the optic nerve for certain people. So I guess I'm not certain people.
Well, I tell you what, I think you want to see.
Yeah, so exactly. So
You got the baby.
Well, okay.
You have to see the baby.
Exactly. Oh, I had a client judge
Mhm.
for Guadalupe County,
Mhm.
and
Yeah, don't.
but Florida does that too. We had a client that came over from Florida because she got stopped on a text on a Bear County warrant. Dollars a day, like the county does. So if someone pays you, puts money for your commissary, Florida takes the $4 a day that they're spending to feed you.
So what happens if they don't put any money on your commissary? They don't
I
feed you?
guess it's all good, but like if somebody's actively putting money in the commissary,
They
they
take
take
it.
extra, they're gonna charge her $4 per day first.
Ah, and then give you
And
what's,
then, yeah, so you have to, if somebody's gonna have extra, they have to pay them $4 a day. And then calculate it for the month, and then whatever extra they wanna give them.
oh, wow, I'm learning something new.
I learned that too, I was like, okay, it kind of makes sense, but all right.
Oh, man. All right, well, have a good one. Good seeing you.
Thank you, good.
You're welcome. Have a good day. All right, have you heard from Mr. Rutledge? All right, can you have an interpreter come down? Yes, thank you. All right, Mr. Cortez,
Yes.
we tried to reach your attorney today. So what we're gonna do is we're gonna bring you back tomorrow. All right? All right, any questions?
No.
All right, just have your family or somebody reach out to your attorney. We'll send them a notice, but if he calls you, let him know he needs to be here tomorrow.
Could you give me my attorney's name, please?
It says here that they're hired. Is this is this a motion to revoke? It's a new case? All right, so they have your attorney as Mark Rutledge and that you hired him. So is this your attorney?
Es que yo no lo conozco, yo, la abogada.
It's like, I don't know. I don't know the attorney.
Un amigo mío fue que lo contrató.
A friend of mine is the one that hired me.
Okay, all right. So, well, your attorney needs to be here tomorrow. And your friend who hired them, you know, if they ask, your attorney didn't show today.
Sacar todo esto, pero
So what can I do so these kind of like ends faster?
The only thing I can tell you is that once someone has an attorney that is hired, that's their attorney. I can't give you any advice with regards to that attorney. All I can tell you is that your case is going to be recalled for tomorrow. The system lets the attorney know that you're being recalled for tomorrow and they should be here tomorrow.
Okay.
All right, thank you. Thank you. Yes, thank you so much. And that is. Are you here for someone? Ah, okay. All right, thank you. And do you have a date for Neelan? Okay. All right, then, so recall him for December. Let me see. Put him down for December 15th. Let's see where we are. And which county is he out of?